Welcome back. You're watching Decision 2017 here on NTV, the home of the real story. We continue with our conversation regarding what will be happening today at the Supreme Court as well, and also looking at what is happening in the counties as well. So we have with us, this is Farah Maalim, who is the former Deputy Speaker of the National Assembly. Also we have with us His Excellency Professor Anyang' Nyong'o, who is the Governor of Kisumu, and also Dr. Shemu Chwodo, who is the Global Leader of Kenya Diaspora Alliance. It is 7 o'clock on the nose, and we're still waiting for Gladys Boss-Sholei, Women Rape, Uasin Gishu County, and also His Excellency Dr. Joyce Laboso to join us as well. So we shall continue with the conversation at pace. Before we took a short break, we promised that we shall be looking at what will be happening at the Supreme Court. And I hope right now we actually done with the issue of the extrajudicial killings, eagerly waiting to hear that particular report coming from the Independent Policing Oversight Authority.
As we leave it, Bal, I just wanted to concur with you that regardless of what we call this matter, certainly it's a grave matter, it's unacceptable. Personally, and I think I said this last week, my own relatives, my nephews too, were removed from where they were staying at 2 a.m. at night in Nyalenda in Kisumu, tortured, taken to the road, beaten, taken back, and then extracted again. As we are talking, one is still in hospital. So it's no laughing matter, but it's better we use the right terminology to call it. But that notwithstanding, it's a problem that needs addressing. And I agree, let's have independent investigation and let it be stopped forthwith, because we don't need to go this route again.
All right, thank you. All right, Governor, we want also to drill deeper on the issue before we look at what will be happening at the Supreme Court as well. You have been castigated, not you exactly, but of course the current governors of firing, the county assembly or the county workers as well, saying, yes, we want to have a clean slate, starting from a clean slate as well. You have also fired some of, or you've given them, I think, compulsory leave?
Yeah,
if I'm given
the law is very clear. If you read the County Government Act, and I think better go by the law, County Government Act simply says that the CECs, when the term of the governor is over, they leave with the governor. The CEOs is a different matter in the sense that there seems to have been a lacuna in the law.
Yes.
Not because it is not clear, but because during the first term, some of the chief officers were appointed a year or two after the county government came into place. And some governors did appoint them on contracts which could go beyond the governor's term. So the Council of Governors has made this very clear in a memo to all incoming governors that notwithstanding that lacuna, the CEOs could still leave, but under arrangement that the chief officer governor determines. One of them is going away on compulsory leave, because some of them also have some issues to settle. So you don't want them to be in the office while you're trying to clean the deck. So we have done it within the realm of the law. It's not a question of some people saying, some people use the language that...
It's unconstitutional.
No, it's not.
But we've had also the Public Service Commission really saying what the governors are doing is not really enshrined in law as well.
Let's make a distinction between the Public Service Commission and the County Service Commission. You are two levels of government, separate but interdependent. You don't want one level of government superimposing its own rules on the other one. So the Council of Governors has written a very clear direction, which if the Public Service Commission is going to comment, they should first of all comment on that communication from the Council of Governors and write an advice on it if they think it's contravening any part of the Constitution. But it's very carefully written, by the way. So I've been a minister twice. I've been a chairman of Public Investment Accounts Committee. I've been a lawmaker for 25 years. So I'm not just about to do something which is stupid.
Thank you. Right, Farah Maalim.
Yeah, I think, as Peter puts it, there is need to deal differently with the political appointments from the technocrats who are there as part of either, who are basically either inherited from the Public Service Commission or employed by the County Service Commission. But then the political employees like the CECs have no business. It's just like, this is a replica. This is a replica of what you have in the central government. And in the central government, although we have got kind of a mongrel, what do you call, in a manner in which we have when we tried to go the pure presidential way, we tried to deal with the CSs, the county, what do you call this, the CSs, the cabinet secretaries, in a manner which is a little bit akin to being employed as civil servants, which is wrong, by the way. Let me tell you, which is wrong, and that bit needs to be corrected. I'm one person who holds that the head of state is at liberty to change his cabinet secretaries as and when he wants. And in the same way, because this person, a man or woman, has got 5 years to perform to Kenyans. He has a right to choose the team that he's going to work with. The same thing also at the county level. The governor has 5 years to perform. It's fair, in my opinion, that the moment he comes in, the CECs themselves would take their permanent benefits the way whatever, the benefits that they have to take, and they go home. If he chooses to bring back some of them, then he can bring them back. But the CEOs, I think, is a little bit different. It's a little bit trickier. It's much trickier in this case. So we are. This is still in a pilot process, by the way. We've only done it for the last 4.5 years. So this is the second phase. It's expected. The second phase. It's expected that certain mistakes will happen, and there's going to best practices are going to come out as time goes by.
All right, maybe yes. Let's see from before we come to the other question.
In terms of the political offices, if one calls it, whether at the national or county levels, CSS at the national and CEs at the county levels,
CSs, yeah.
I think the governors and the president would be right to decide who they feel they need to work with. But when it comes to the technical levels, both at the national and county level, I would want to think that what we allow to prevail is merit. Professor J.B. Ojwang often says that 3 problems that are bedeviling Kenya, and I fully agree, are mediocrity, political expediency, and ethnic bigotry. I would want to believe that our new governors, or newly elected or re-elected governors, would want to demonstrate what we may not have been able to see at the national level, of merit taking center stage. Having said that, in the counties, 1 or 2 counties in Nyanza have had governors say, I'm going to sack those who didn't campaign for me, who didn't support me in the elections. That would be the wrong way to go. And of course, Kisumu is not one of those counties that have made that statement. If that be the case, then certainly that's a wrong policy. But having said that, at the national level, because we may not come back to this topic, I am hoping we'll get to a stage where government, parliament vets even companies that we call consulting management firms that recruit in the public sector. I know many eminent Kenyans who would never apply for a government job because they know if somebody is good, you would never be shortlisted because then you would block people who are earmarked to be in those offices. I'm hoping that this cascades down to the county level, that we allow merit and confidence so that Kenyans who are eligible for offices, whether at national or county levels, can apply and we get the best. Otherwise, Kenya will forever remain a sleeping giant, whether again at the national or county level.
All right. And Professor, you want also the parliamentary system of government at the county level, where the executive...
No, that was wrong. The fellow completely misunderstood me. Yeah. I never said I wanted a parliamentary system. Some of these journalists, when you're speaking, they are hearing their own things.
I mean, this was misconstrued from what actually...
Completely wrong. And
you couldn't possibly be running for a governor
really, it's wrong.
And then be supporting again parliamentary system. No. Because the leader of the parliamentary system...
You see, if you had read my articles in the Star and other articles, what I've been arguing since independence, actually, I've been a strong supporter of parliamentary system. Yeah, at the national level. Yes. Because in multi-ethnic society, in multicultural society like ours, having a presidential system is a disaster.
I thought that would be your train of thought as well.
So but you see, when I read it, I said, this fellow was not listening. I mean, if he was listening, he didn't understand, which is quite possible. Okay. I never said a thing like that, and so please just delete it from your memory. Just delete it.
All right. Yeah. Okay, but what do you think about what is happening? Because I think we have a lacuna. Yeah. What we are seeing coming to the fore as well is a lack of a smooth transition.
Well, right? That's true.
Yes,
that's true
because we had the transition authority to be there to actually aid from one successive county government to the other as well. Even the issue of now the employees as well.
Yeah.
Now, the assumption of office a bill, I wonder if actually also captured this, because it seems maybe we're having this particular problem right now, then it will be swept under, then again we'll be facing the same challenges when we go to 2022 as well, with the new governors as well, or maybe if you retain your seat as well.
Paul Omatangi's bill on the assumption office was very good.
Yes.
Unfortunately, time ran out for us to pass it in the Senate. I think it reached the third reading, and we were so many bills in the third reading the last couple of weeks. You remember the campaigns really interfered with a lot of things that we're doing in the Senate.
Yes.
So I would believe, I would request, and since Paul is going to be in the Senate, I would like Paul to resurrect that bill, assumption office bill, very early during the time of the 12th Senate, so that we have it in place. Because one of the things that's happening is that the assumption of, transition from one regime to the other at the county level is now very subjective. For example, I didn't understand why the outgoing governor in Kisumu didn't come to hand over the reins of power to me. Other governors did it very well, Governor Kidero, Governor Isaac Ruto, and so on. Very civil, you see. And secondly, we are having problems in Kisumu County. The governor has refused to surrender the cars, petty things. And you find that the kind of petty. There should be a procedure known to everybody that when you lose elections and when the name of the elected individuals have been gazetted, you begin the process of handing over, and there should be an institution doing so. Now, we did have a transition committee in Kisumu, which was being driven by the county commissioner, but it was much more focused on the swearing-in ceremony than anything else. Now, the swearing-in ceremony is not the only handing over exercise. There's a whole host of things. How do you hand over and make sure that assets and liabilities of the county are known by incoming governor and his team? How do you introduce the people you're working with and give in handover notes? This fellow is a rogue, that one is a good performer, send that one away, and so on. Those things are important in handing over. That's what handing over is. But in my case, we went there and we just have to start as if it is a tabula rasa, which I think is very untidy. So I do believe that Senator Omatangi's bill is extremely important for the future devolution in this country.
All right, so it is in the third reading. Is it waiting for the Senate?
Well, but
the
rule is that when one parliament comes to an end, all the bills and whatnot also collapse. You have to begin anew, afresh. Yeah, you see. So I have a feeling that since we have a continuation of some senators who were there before, they will be a much.
They will carry on with that.
They will carry on with that, but the new senators must debate them afresh. They must be tabled for first reading, second reading, third reading, and so on, because this is the 12th Senate, the 12th Parliament. The 11th Parliament is gone, so the Senate, as part of the bicameral chamber, and the National Assembly, they have to start their jobs all over again.
Right, thank you. Yeah. Okay, I wanted now to look at the Supreme Court. Of course, sub judice will not really allow us, but it is in the public domain, this particular discussion as well. We can just discuss it to some limit. And the issue of, this is where we'll pick the mind also of Shemo Chwodo, the issue of IBC's access, or IBC's server, that the NASA really want to access the server to get to the logins as well. We've heard also from the Uhuru side, or the President Uhuru side now defending and saying, of course, this will sort of compromise the integrity of a system if now they're allowed to actually get the logins from the server as well. From your expertise as well, because they said that this has not been backed up. But I think the way systems are actually configured is there is an automatic backup that really happens. For any data that really comes in, there's an automatic backup for sensitive data as this, because in case of anything, you lose that particular data and you've not really backed up. Do you think this was just a trot of excuse from the lawyers as well, or there is any merit in this particular argument?
Debal, I take cognizance of the reminder that the sub judice regulations may not allow us to get into details on this matter.
Yes.
But having said that, I think yesterday, what we witnessed happened last night, confirm what I think have been crying all about, that we overcredit our lawyers. Why do I say this? I say this because yesterday I'd hoped that some technology professional groups that are credible and partisan and so on would have been called to bear when it comes to the aspects of technology. but I witnessed, I was saddened that ICTAC, one of the bodies that went forward, was not allowed to be enjoined as an amicus, friends of the court, but not surprised. Not surprised because I think it's also an indictment of the leadership of the ICT sector, that why have we not brought order to this sector? A couple of months ago, Nation newspapers carried an article I had on ICT where everybody is an expert, even politicians, no training at all in ICT. Every profession has got to go through some rituals to be experts. Unfortunately, this is a sector where everybody is an expert and the leadership has not done much. The sad thing is that ever since this sector or ministry was created, I've never seen ICT people proper, and they are in the country, not that the country doesn't have them, both within and outside the country. But that's an indictment, despite the fact that this sector could do so much. But coming back to the Supreme Court matter, I would, my advice, perhaps for free, to the parties in future to invest more in technology expertise and resources, but also a matter that we have talked about here before. Each time I kept asking my colleagues here, there was an ITAC, a technical committee, which is legislated. It's a statutory body in the Kiraitu Orengo law, the Joint Select Committee, that established a technical committee, which vanished. I was only surprised to read in the affidavits of some of the petitioners or the witnesses that this committee was disbanded by a court, and some actors were not even informed of it. So I'm really wondering, I'm at a loss. Maybe Professor here may enlighten us. How come this happened? Where were the representatives of the respective parties, Jubilee and NASA, when this was happening? Why did it not come to the public domain? In the absence of that, I'd also hoped that the bench would have benefited from expertise. At one time, I read they had foreign experts in this sector. From what I witnessed last night, I don't think we're likely to do justice to the aspect of use of technology in this element. And probably that's what I would say for now, which would be very unfortunate. Going forward, I think this is a sector we need to improve on in terms of election management.
But aside from actually this, the specifics of this particular case as well, not from your own expertise, this is what I'm asking you. Right. When we're talking about the backup itself, we presume, or yes, the norm is that, of course, we have a very sensitive data that you want to protect. So the issue of backup, that we need to back up or interfere with the integrity of the system, does it really come, does it hold any water? It may not be so straightforward. I've seen people suggesting, look, next time you get appointed people, experts in databases and so on. I was a founding president of the Very Large Data Africa Very Large Databases Forum. But I know this is more than databases. It's databases, it's networking, because when it comes to transmission, it's a different ballgame altogether. I remember we did recommend to the panel that was recruiting commissioners, make sure that at least 2 of the commissioners have technology expertise. Well, I do appreciate that they were saying, look, we are hoping that these ICT people who are eligible would apply for these positions. But that's a problem that doesn't seem to have been taken care of. I may want to extend the same call in future. Even the Supreme Court judges, let's also have those who are experts, who straddle both fields. Yesterday, I saw Professor Ben Sihanya in court on the NASA side. I do know he has got some leaning towards technology, and I was expecting that he would be a bit more at the forefront, but that was not to be. I think we need to get to a stage we realize that we are so dependent on technology. But having said that, your direct question was on the backup. Yes, I would be very surprised that a system does not constantly back up, but it depends on the amount of data, and it depends on the systems that are being deployed. I've had contradictions of SQL, of Oracle, and so on and so forth. I don't honestly have those details. I don't know how frequently the systems are backed. Are they done daily, or every 24 hours, or how? But I'd expect them to be regularly done. But that's notwithstanding, access to the system, I think, are matters that should have come out with what we call process flow.
The process flow is what the ITAC, the technical committee, keep going to. Is the one who should have said, from this point, how do you enter data into the system? From this point, let the agent sign and so on. But that doesn't, I'm not privy.
But access to the data and finding out all the details of the logs, how does it interfere or compromise the integrity of a system?
Debal, once you access a system, what you do with it, I really wouldn't tell, because I don't even know what database we are talking about.
Debal, to me, I think there are three things that are important as sources of information in this petition. From 34A, KIEMS, Kenya Integrated Electron Management Systems, and the server. And I want to refer you to the Constitution. Article 35 of the Constitution of the Republic of Kenya. Access to information. And the article says every citizen, and I believe that those petitioning are citizens of the Republic of Kenya. Every citizen has the right to access to A, information held by the state, IEBC as state organ, and B, information held by another person and required by the exercise or protection of any right or fundamental freedom. Election is a fundamental freedom in our Constitution. Exercising your right as a citizen to elect your leader or your representation, and it is an exercise of exercising your sovereignty under Article 2 of the Constitution. And I read you Article 2 of the Constitution. Article 2 says that, let me just see, which is very important. Article 2 of our Constitution says, Article 1.2, sovereignty of the people. All sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this Constitution. 2, the people may exercise their sovereign power either directly or through their democratically elected representatives. The first 2 articles of the Constitution tell you that you're sovereign and how you access it. The Article 35 tells you that as a citizen you have a right to information. And in this case, we have a petition dealing with the sovereignty of the people and their representation, and they need information to prove that the sovereignty was exercised in the election. If you go to Article 81, General Principle of the Electoral System, go to 81E. Let me just read 81, because if I don't read it fully, you don't understand what I mean. 81, the electoral system shall comply with the following principles. A, freedom of citizens to exercise their political rights under Article 38. B, not more than 2/3 of the members of the elected public bodies shall be of the same gender. C, fair representation of persons with disabilities. D, universal suffrage based on the aspiration for fair representation and equality of the vote. And E, free and fair elections which are, and this is what I'm coming to, free and fair elections which are, 1, by the secret ballot. 2, free from violence, intimidation, improper influence, or corruption. 3, conducted by an independent body. 4, transparent. And 5, administered in an impartial, neutral, efficient, accurate, and accountable manner. Access to 34A, KIEMS, and server will help us find out whether this thing was administered in an impartial, neutral, efficient, accurate, and accountable manner. One of the reasons that we wanted an electronic system of administration of votes was to implement this principle in the Constitution. And now we are saying, unless we look at KIEMS and server to find out whether these were actually used to implement 81E5, then we have not gotten the information that we need. And Article 35 of the Constitution gives us a right to get information from the state and any other body when we need it. So it is important that the court respects the Constitution of the Republic of Kenya with regard to the request by the petitioners.
All right, let's hear from Farah. before you come to you, Farah, because Pandis is saying that the weakness in the judgment of the Supreme Court on the 2013 presidential petitions, pointing out that unless the court is prepared to depart from the reasoning it adopted in 2013, it is likely to dismiss the election petition that is currently before the court. And of course, a lot of requests were made in 2013. We shall be looking at them as far as we're concerned in this particular program with the few remaining time that we do have. Do you think that particular judgment that we had in 2013, of course, will come to bear with this particular Supreme Court that we do have? They're the same people who started in 2013, the same template they had in 2013, also maybe in a way will actually come to bear with this particular judgment that we do have, because also NASA has expressed bugbears and fears that these are the same, the composition of the Supreme Court still remains the same, and this also might filter with this particular ruling that we do have.
There's a very important, very important sanctified provision in our own constitution. I will find out the article, which says that substantive justice cannot be sacrificed on the altar of technicalities.
Yeah, exactly.
That's a provision in the Constitution itself. Now, we have a problem. We have also technicalities that are constitutionally in the Constitution itself, like the 2 weeks itself. We made a mistake, even in the opposition and the government side, not to have insisted on a constitutional amendment that was going to give the judges not less than 30 days to determine matters of petition. And I can say,
from the 14 days.
Yes. I put that blame squarely on us, on us also, on us in the opposition.
Yeah.
We should have been able to agitate for this, and I mentioned this many times myself.
And it came to the floor of the House, isn't it?
Well, you see, when you can't get it through the floor of the House.
With the 11th Parliament, it was there.
Yeah, but you see, the tyrant of numbers was there. And yes, when you don't have that, then we should have initiated a process in which we're going to go to the people. Because that provision is there of collecting the 1 million votes, 1 million signatures. We were supposed
But we tried to Okoa, Kenya.
Yes, hang on a minute.
And very frustrated.
Hang on a minute, Prof. I frankly put even the debacle we had in Okoa, Kenya, square on ourselves. Yeah. Why did we have to wait all the way from 2013 and then to bring this thing 1.5 years to the election itself, or 2 years to the election? You see what I mean?
Yes.
Why did we keep the numbers?
Yeah.
We should have been able to collect these numbers in less than 3 months. And we should have been able to collect 3 times, 4 times the numbers that are needed. Yeah. If we only went to the number of people who were said to have voted for Raila Odinga in 2013, we would have had millions of signatures. You see what I mean? And that should have been with the IEBC as early as the beginning of 2014. We never did that. So that we also blame. I blame it on our side, and I've mentioned it many times myself. But instead of clogging even the Okoa, Kenya, what do you call things that we needed to repeal, and coming up with a raft of 15 different issues, we should have come with 1 or 2 people. There are only 1 or 2 issues only. Anyway, having said that, anything could happen. They could follow the president, in law. There's locus classicus, precedents, cases, determined cases before. Yes, and the Supreme Court is the highest court in the land. And the possibility of them saying we will proceed on, I see myself a serious split within the. I don't want to discuss I'm sorry again. I think I've delved into an area because I'm a legal mind too, and I shouldn't be able to go into contempt of court and debating what you call the merits and the demerits of this thing. But we will wait and see. But anything is possible. I may say that. Anything is possible. We might end up saying we need to have substantive justice and forget about technicalities. And we might also say, look, the president has been set there before by none other than the Supreme Court under the guidance of one person who is highly respected in the country and the globe also, was William Mutunga. We never had the real manners in which they voted and what was the opinion of everybody. This is also another problem, because in the Supreme Court in the U.S., which we want to try and emulate, if there's a dissenting voice, the dissenting voice itself is recorded.
Just to
So we never do. We don't know. We don't know what happened. We don't know what they discussed. We don't know how this decision was reached at. We just have a judgment. You see what I mean? So basically, and that judgment seems to have a unanimity in that case. Whether that unanimity was factual or whether unanimity was a decision on their part to say that let's not have a split vote because we want to save the country. We might, if we have a split vote, you never know.
Yeah.
Right. That was also another argument.
Before we come to you, Prof,
it could go in any direction. Yeah.
Before we come, Shem,
Prof, I have a lot of respect for the ladies and the gentlemen of the Supreme Court, especially the Honorable Chief Justice, that's President of the Court, and I wish them well. I am hoping that they'll be able to deliver no lesser than justice to Kenyans in determining this matter. Having said that, I wouldn't want us to run away from the technology part because this is very core to this particular election.
Yes.
I am one of the people who is very happy that we have come to this stage where I would say about 50% of the electoral system is automated. And I think that's progress, a progress that I think even other parts of Africa could pick a leaf from. And I'm equally delighted that IBC is thinking of in future elections that we'll be moving closer to 100%, maybe 80% or 90%, because even voting and so on can all now be done through technology. So I'm happy that we are making that progress. But equally that has to go side by side with enabling legislation. I know there was an attempt through the electoral technology regulations to bring this to bear, but maybe we didn't go far enough. We need to refine this further. We wouldn't have been perfect. I think the fact that the system worked, I think most people would agree pretty well up to the tallying and transmission of results stage. That itself, for me, is commendable to IBC that this happened. Of course, that's not to say there were no problems in identification here and there. But by and large, I think there's consensus that the major problems came about when it came to tallying and transmission of results. Having said that, I think, and I want to perhaps for free, I can share with Professor the Article 35 that he cites that talks about access to information. Freedom of access to information. It doesn't talk about freedom of access to servers. And there is a difference here. Because very often when you want information from, say, Treasury doesn't get you into their servers to go and get that information. I'm not saying that it would be wrong to ask for. It would be right to build confidence. If we think there's something nasty that happened in the clouds, in this particular case, I suspect much of it happened in the clouds. It may not even be the servers in terms of physical that we are thinking of. But a petitioner or a respondent would have the right to give confidence to have access. But in that case, we need to work on our laws. So it doesn't have to be in the Constitution. It could be in electoral laws or in the regulations saying that there should be free access to the technology that was used. And in its absence, I go back to the technical committee. That's the one that should have specified. Even at the time the presiding officers are entering the results, the Form 34A, into the system to be transmitted. It would have been a requirement that let all the agents to be there to be sure that what's being typed is what's right. And even at the receiving end, that there are agents to ensure that what's received is the right.
Because this is really domiciled in Article 35. But Prof, if I may remember also that we have the Access to Information Act that was sent to by the President. So what is really captured in the Access to Information Act? Because you say that, and we have it here, that every person has a right to the correct or deletion of untrue or misleading information that affects the person. This is all, of course, the right of the citizen.
Right.
So we cannot truly say that, as Prof is saying, it is totally denying also access to the servers, right? Wherever the information is domiciled, a citizen has a right to access that particular information, doesn't he?
Yes.
Right? Because we have the Access to Information Act as well. So was that also put there to aid this or to elaborate this as well?
Let me just clarify. You see, the electoral laws that we amended in Parliament, which one was saying, where the government was saying they want to allow for mechanical or manual voting. If you look at the rest of the law, it's very detailed in terms of issue of access to information. Okay. And I don't think we need to split hair on that. That's something that the court can settle. I don't want to go into it.
That would be their own interpretation.
Yeah, I mean, surely, because I agree the Constitution only lays broad principles of law, and then Parliament has to pass the laws which then implement these principles. So we'll find it in the Freedom of Information Act as well as the election laws. They are there. I don't have the thing here, but remember our debate to the Parliament. So now it's upon the courts and the lawyers to sort out that. But let me say the following. You know, we as citizens, sovereign citizens, when we go and line up to vote, and voting is a ritual in this country, by the way. In my village, on the day that we are going to vote, people wake up very early. You hear people singing and so on. And also the day that you meet your sons and daughters who have come from Nairobi to vote. So the line is kind of a community celebration. And they have a faith that when they cast their vote, it will reflect their preferences. And they will go away after they cast their vote. Their fate is entirely in the hands of the IBC agents and so on. Then what happens? And I'll give you two stories. In Meru North, when the presiding officer remained there, he chased away all other agents except those of Jubilee. And what did they do? They realized Raila Amolo Odinga's votes are 420, Uhuru's about 28 in that particular place. Raila Amolo's ballot papers folded up, given to somebody, told to run away with. We saw that in 2013 when we discovered ballot papers which are marked in toilets in Uasin Gishu. So the innocent Kenyans who stand all day ritually voting and going away finally doesn't know whether his vote counted or not. This is why having access to 34A, KIEMS and SAVA will help us cure the mischief.
You know, Dibal, when you have an article in the Constitution, an article like this, it is looking at the global context. It is looking at the holistic context of access to information. And it's not just looking specifically designed only to cure problems on electoral problems. Information has been there. For example, Peter has been put in jail in the past and many times harassed because he was fighting for change in this country as a young man. And you don't know what kind of information that's there on him. They could have an information that says this is an agent provocateur, he's a communist, the kind of stuff which was there. He works with anything. That's why the deleting and everything else and the deletions were there. You have to correct that information which is wrong, which is in the domain and the custody of the government itself. The issue now is, this is information that's in the custody of the IEBC. The IEBC is not an arbiter in court. It's a public institution that's supposed to arbitrate, or rather conduct a process that will determine who among two people wins the presidency of this country, or who among these two win. It's supposed to be an independent arbiter. For that independent arbiter to say, for purposes of clarity, for purposes of building the faith and the trust, this is the information, this is how it's going to come through our place, and this is how it's going to be reflected. You can rest assured that your votes will never fail to be captured. And to show the server itself is a sense of building trust, because that's what the body does. It's not information on other crimes, it's not information on other things, you know what I mean? The government, there's secret government information. For example, the government is not expected to tell us the confidentiality and the top secret of the government you can't go and demand, because there's a provision in the Constitution on our military structure, on our strength in there, in the different artillery, the air force, you know, those things you don't have to have access to that. Nobody's going to get access to that. Every country has got its own top secrets. But because this is information that affect the lives of ordinary Kenyans in a day-to-day purpose, day-to-day. And I think to say that access to information and access to SAVA are two different things is to try and play with semantics, to try and run away with, basically. You see, there has to be utmost good faith in anything that an institution does. That utmost good faith has got to be there, and it has got to be seen to be there. And I think when we're looking at these things, and I'm sure the courts and I don't like the way IEBC is behaving right now. If I were IEBC, I would say, fair enough, this is the information. Come and see it. We've done a good job. It's a fair job. You have to be satisfied that whoever lost and whoever won, as per the will of the people. But to say, no, we can't give you access to this, no, we can't give you access to that, the issue that arises is, what are you hiding?
Mm-hmm. Right, okay.
So these are the kind of things that basically, and I think what happens, by the way, in any resolution or determination of a matter in court, right. One thing that people have to look at is what were the intentions of the framers of that particular. We never look at these things, Peter. I think we have to have a system in which we have to indicate what were they supposed to cure, what mischief was this particular provision or article in the Constitution supposed to cure. Once we have that in place, I think we'll have a lot of issues.
So we look at it with
instead of just
fine,
looking at we look at what did we intend this particular provision or this particular article to cure, because every article in here is intended to cure a problem that we have suffered one way or the other.
All right.
What Mheshimiwa Farah is talking about reminds me of Eke the bird in Chinua Achebe's writings. That Eke says, since man has learned to shoot without missing, the bird has also learned to fly without perching. And for me, this is part of, we seem to be, for the court, there is just jurisprudence being built. We recognize there's a problem here, and I want to look at it more futuristically than now. How do we keep incrementally improving on our systems? We recognize there's a problem, how do we seal the hole? And the same applies to electro technologies. I think if we are to be honest with ourselves, let's admit there are some gray areas. Personally, I'm not holding brief for anyone. I'm not saying IBC shouldn't avail access to the information. I think some of the respondents were saying now they would not mind the petitioners accessing some of this information. But for heaven's sake, even if assuming a server was opened and we have the string of very eminent lawyers that we have, I kept hearing people saying, we need this length of time, a number of days, a number of hours, a number of minutes. With due respect, this needed to have been clearly stated in regulations so that you can hold somebody to account. For now, we are at the mercy of IBC saying, because, and I insist, I had some lawyers argue, rightly so in court, that now some people are looking for you access to evidence, not access to information. That is itself a thin line. I don't totally agree with them, but I also cannot rule it out, because there is a little gray area. Because normally the understanding is if one is looking for information, you know, like NASA leadership did table some printout, which was like evidence. Whether it's authentic or not, I really don't know. I can't vote for that. Ordinarily, when you say you need information, the ordinary Kenyan would have no clue. The majority of Kenyans are computer illiterate. So even if we are thinking of the framers of the law, they had the public in mind, not the few of us who are elite who can access technology. But in this regard, so my premise is, for me, for the technology, there's an important point, final, which I wanted to say. And it's something allow me to keep singing about. At some stage, and this doesn't only apply to Kenya, it should apply even to other countries, including the US, declaring electronic systems as national critical infrastructure. If we did that, then we would protect them, military level protection.
Fantastic.
Because
that is going way forward. Let's now tackle what we do have right now, because actually we are stuck in a rut right now. But moving forward, a national critical infrastructure, the electoral system should be a national critical infrastructure. But at this juncture, because also we really strapped for time, I wanted to know, as the custodian of electoral records, the IBC does bear the burden of making such records, as we're talking about, available when these are needed to resolve disputes. Isn't that the case? Because even me as a citizen, with the information that we've been given to the Access of Information Act right now, I have the right, if I want to go to IBC, to access this particular information, right? So even in the absence of disputes, as one correspondent was writing, I think the article, he says that making its electoral records available is part and the burden of accountability that the IBC must discharge. That there is also an assumption that the IBC will act with integrity in the management of the records in its possession. Missing, incomplete, or forged records strike at the heart of accountability on the part of IBC and also undermines the equality of arms on which the burden of proof is founded.
Yeah, there's an important point.
The IBC,
right.
the IBC is supposed to be a neutral arbiter here,
True,
right?
agreed.
So it should not be actually cagey with also information as well.
Yeah,
Just my thought. This is what I'm throwing up to you. I'm not saying this is my statement as well. Yes, please.
The framers of the Constitution had in mind the Kenyan citizen, whether elite, mass, but the Kenyan citizen, which are described as the sovereign. With disregard to their class, education, and so on, the Kenyan citizen. That is what is the Constitution. Secondly, I think we must await Willy Mutunga's autobiography, because when Willy Mutunga was inaugurating his court, he said, and I remember very clearly, that dispensing justice to the people of Kenya will not, under my charge, be held back because of technicalities. Yes. Say that very clearly. So when we came to the Supreme Court decision, or last in 2013, and it is allowed the court petition because of technicalities, it was a contradiction. That's what I'm saying. I await the autobiography of Willy Mutunga to find out how he reconciles the principles he enunciated when he was inaugurating his own court and his final biggest act in Kenya's history on making a decision on 2013 on a basis of technicality.
Let's say from Farah, we'll come to you.
Yeah.
From Farah, we'll come to you.
I don't know exactly what happened, but of course, rumors were abuzz. And I'm sure Willy Mutunga is going to put that into his memoirs at some stage. Because I'm told the poor guy was one of the very few who dissented in that. But because of the precariousness of the situation we had that time, I think he went with the majority. That's why they had only one ruling, only one judgment. But by having said that, at the risk of being seen to discuss something that's in court, which is not right, by the way, we can only talk about the holistic ideas and concepts and principles here, but we can't debate the merits and the demerits of the case itself.
We're not.
We're not doing that, yes. So
we're debating ideas.
Yes, we're debating ideas, yes. We're debating ideas. Our brother, Shem Ochido, seems to have a lot of faith in the electronic system.
Yes.
I equally had a similar faith in the electronic system, but without going too much into why I don't think I have as much faith as I used to have before, you can have the system, for example. You can have the system, but the system is operated by somebody. The system is not foolproof to the extent when you come in as a voter and you put your thumbprint in there. You still have somebody who has to validate that. You see what I mean? Mm-hmm. You have somebody, a clerk, who has to validate that and say, voted. If that clerk chooses not to validate that, that person can vote 10 times. You get my point?
Yes.
That person can vote 10 times. I'm not going to go into some of those details, but that basically is a reality we have to live with. So we have to, in the next time when we're trying to refine this for posterity, we have to come up. When you come in as a voter to a polling station,
yes,
you will come in as a voter, and of course, when you are found, the machine has got to self-validate itself immediately, instantly, without having a clerk to put in there. Now, I pity two groups. I pity the IEBC. IEBC is a very big body, but only the returning officer and his deputy returning officer and the county, what do you call, manager, are employees of IEBC. The rest of those clerks out there, the presiding officer, the deputy presiding officers, are people who are recruited
by the returning officer.
By the returning officer a few days before that.
Yeah, sure.
So those are the ones who can either give us a credible, what do you call, election, or a discredited election. But then how much responsibility can IEBC take on that?
All right.
That is another issue. Now let me the other bit I want to say. I also pity the Supreme Court. Because the Supreme Court, how many pages of evidence have we taken in there ourselves?
150,000. About 100,000.
Yes, 100,000. How humanly possible is it for these people to go through 100,000 pages in a matter of days here and come up with a
sensible judgment?
A sensible judgment. We have a problem in that also. So there is a serious problem, and I personally would want to see us sit back, whatever the results of this, whatever the determination of this case is going to be. The country needs to go back again into meditation, and see how we can cure some of these problems so that in future we don't have problems the way we've had it now. Because it could go either way, like I said. It could go by following the president. It could simply go by following the president because they don't have sufficient time to go through these mountains of evidence.
But we blame you, the legislatures. No, we blame you, the legislatures.
For having
yes,
failed.
you failed Kenyans.
I took that responsibility.
We are the people who actually put it to in the legislating house to actually make sure we don't have these kinks and having all these wrinkles within the system itself. You had this particular problem in 2013. You glossed over it. Now we're coming to the fore. We're still talking about page documents. We are talking about 14 days. You are squarely to be blamed. You're the people who are letting us down.
We must not do it again.
Please, we must apologize to Kenyans this morning. Because this is what we are facing here. People now are still twiddling their thumbs, wondering what will happen with the same issues that we talk over. And this is what we normally have with this country. We gloss over things. We don't squarely address issues.
I talked about that myself. I talked about from day one. And many people, including Peter, we had discussions. We said that's what we need to. Instead of loading that thing, instead of taking ages to bring in that Okowa Kenya, we should have just taken a few months and taken on 2 issues or 3 issues. That's all.
Right. Your parting shots, please. 30 seconds, Dr. Shema Chodho.
I think we recall the Professor Guy's committee was even talking of 7 days. So I gather that the 14 days was a negotiation. But obviously, we all agreed that the timing may not be enough. But in terms of the point Farah was raising that many pages within the time limited, I'm gathering that this is why the petitioner and the respondents, their submissions are going to help guide the judges. But I agree, Honorable Farah and I are saying one thing in different ways. The problem is not the technology, not the technology. Of course, the electoral system includes also the people. The problem is with the people, and that's probably where we needed to address. But part of why I was saying when it comes to the issue of, although the constitutional intention is access to information, you know, in this particular process, and one thing that my colleagues are ignoring, I want them to pay more attention to it, is the process flow. From the time, how do we know that what was keyed in was right? That there could be a problem in the presiding officer could key something wrong. We didn't have protection for that. That has got little to do with the server. How do we know that what was transmitted was not intercepted and altered? That's nothing to do with the servers and so on. And this is part of why I'm saying that where we need to focus, improving the process flow.
All right, thank you. Professor, very briefly.
Briefly, I just want to, Shem said it earlier, but as Governor of Kisumu, I really want to pass my deep-felt condolences to the family of Mrs. Christabel Uko. Yesterday, we were together with the family, relatives, and friends at Sitam on Valley Road, one of those vigils at night when we remembered Christabel, a real gem for the people of Kisumu. She really has done a wonderful thing in the county, things in the county, all these years, especially after the demise of her dear husband, our late brother and friend and ministers, John Robert Uko. And we will be laying Christabel to rest on Thursday this week in Koru, the Garden of Eden, really. If you go to her home, it's a Garden of Eden. She's just made wonderful home.
Thank you.
And with a lot of social services around, a library, a school, very good interaction in the community. So we're losing a mother, we're losing a sister, we're losing a gem in the Kisumu County.
Thank you.
God bless her. Rest us all in peace.
Thank you. Thank you. Farah Mali, briefly.
Yeah, my parting shots would be, Dibal, I represented a constituency in this country where we had 600,000 refugees who escaped conflict in Somalia. And in that refugee camp, I saw professors, I saw former ministers, I saw former generals, I saw all of them coming into the place just as refugees, pure and simple. Not even a name, not even a title, but just as refugees. And that's because there was a conflict in Somalia. I want to call upon the Kenyan people that whatever happens, whichever direction it takes, both the government and the political classes should make sure that there is no violence in this country.
Thank you.
We can destroy, ours. We will not be able to get it back together in
many years.
Decades.
Yes.
Somalia has not been able to come together now for the last almost close to 30 years.
Thank you.
And you're looking at something similar to that. And that's a homogeneous society, by the way.
Thank you.
We are not that homogeneous as they are. So let us watch peace and protect peace.
Important.
That's the most important.
Thank you. Farah Maalim, the former Deputy Speaker of the 10th Parliament, thank you for coming through. Also, Honorable Anyang' Nyong'o, Professor Anyang' Nyong'o, the Governor of Kisumu, thank you for coming through. And Dr. Shemu Chwotho of the Global Leader of Kenya Diaspora Alliance, thank you for coming through. Also,